Hello, everybody. Your doctor's been sued many times before, and now you want to bring a lawsuit, and you ask the question, can you use his history of prior lawsuits in your particular case? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. So now the short answer is, no, you cannot use that. And let me explain why. So let's say, for example, this is a medical malpractice case. And now you're contemplating bringing a lawsuit against your doctor claiming that he violated the basic standards of medical care. And you believe that his carelessness was a cause of your particular injury. And you believe that his carelessness was a cause of your injury and that your injuries are significant and permanent. So now, here's the question. You want to bring a lawsuit against your doctor. You think he was careless, causing you this significant injury. You don't know anything about his history in terms of his legal history. You find an attorney who's willing to go ahead and investigate. And your attorney goes ahead and starts a lawsuit on your behalf only after getting confirmation by a medical expert that, number one, there was wrongdoing, your doctor was careless, his carelessness was a cause of your injury, and that your injury is significant or permanent. In New York, you can only go ahead and bring a lawsuit if you have confirmation by a medical expert in each one of those things. So now, here's the question I asked. If you learn during the course of your lawsuit that your doctor has been sued many, many, many times, you might be thinking, hey, wait a second. That simply justifies the fact that you brought your lawsuit. That simply confirms your belief that your doctor was careless, not only with you, but with other patients as well. And you may think, hey, you know what? I'm sure that when we get to trial years later, that we'll be able to use this to show the jury that this guy was careless, to show the jury that this guy didn't know what he was doing. So you have that perception, you have that expectation, that anticipation, because now you learn at the beginning of your case, as your attorney is starting your lawsuit, he calls you up and says, hey, by the way, just want to let you know, this doctor has been sued 25 times before over the course of his career. And you're thinking, yes, we can use this information to show that he was wrong in my particular case. Well, the answer is no, that's not what you can use it for. There are other things that you can use it for. However, you will not be able to use those other cases at the time of trial. Let me tell you why. Hang on one second. Let me get some water. And I think... Okay, so let me explain why. In a medical malpractice case, for example, we have an obligation to show that we are more likely right than wrong, that what you are claiming is true. So now, if we were to go ahead and try and use the doctor's prior history of lawsuits in your particular case, the defense attorney would immediately jump up out of his chair, yell out, "Objection, Judge! I object to that! That's prejudicial!" And you know what? He'd be 100% correct. It is prejudicial, and I'll tell you why. The jury is going to believe, just like you did, that simply because the doctor has other lawsuits during the course of his history, during the course of his career, that automatically means that, hey, if other people have sued him in the past, that must mean that he did something wrong in your particular case. Well, that's the logical progression that you would like them to have. That's the logical progression that your attorney would like them to have. But the reality is that it is highly prejudicial. Now, what does that really mean? It means that the jury is going to get the perception that if they are allowed to learn about the doctor's other lawsuits, then certainly they may be thinking, hey, people only bring a lawsuit if they believe strongly that they have a valid case. And in New York, we have to get confirmation by a medical expert that there is, in fact, a valid basis for a case. So if all those other 25 people went ahead and brought a lawsuit, surely they had to have a valid basis for a case. Well, from the defense's standpoint, from the doctor's standpoint, the answer is no, that's not actually true. Although a medical expert may have confirmed that there is a basis for a case, it does not automatically mean that the patient was correct. It does not automatically mean that the doctor violated the basic standards of medical care. You should know that when you bring a lawsuit seeking compensation, seeking money as a form of compensation for all the harms and losses and injuries that you suffered, they are allegations, and allegations that we have to prove, not beyond a reasonable doubt, But instead, we only have to show the slightest bit that we are more likely right than wrong. And then you'd be entitled to a verdict in your favor. But if you look at the doctor's 25 other lawsuits, not all of them went to verdict. In fact, very few of them went to verdict. And the mere fact that somebody brought a lawsuit and may have settled it, that establishes nothing, absolutely nothing conclusively. And we cannot use that result in your particular case. So now, what about a case that actually did go to trial and now a verdict was rendered? In that instance, now we can actually use the verdict. Now we can go ahead and question the doctor at trial during cross-examination about some of the facts of that case, about the results he obtained in that case, and now we can use that because that's been conclusively decided by a jury, and ultimately the appeals process has been exhausted. So only in that instance where there has been a legal finding, either by a judge or by the jury, and now the doctor or the patient's attorney has exhausted all of the appeals, now there's a definitive, conclusive answer as to whether or not the doctor violated the basic standards of medical care, causing this patient harm. In that instance, we can use it. But simply, and the mere fact that someone has brought a lawsuit against somebody else is not evidence of anything. And if we try and use that information at trial, guess what? We're going to get an objection sustained from the judge. That's going to basically say, hey, counselor, you cannot ask that question. And doctor, you are not to answer that question. And if I try to do it repeatedly, the judge is going to get angry at me. He may hold me in contempt. And now he's going to find a remedy to go ahead and sanction me or fine me for continuing to do or ask a question that I know is improper. And it ultimately, if I keep doing it, or any attorney, if they keep doing it, the judge could turn around and grant a mistrial because now what we've done is we've poisoned or tainted the jury. And now there's no way to positively go forward with the case and to get a fair, impartial result from the jury. So, to go back to the original question, can we use the doctor's past history of prior lawsuits as evidence of wrongdoing in your particular case? The answer is no. And let me give you a great analogy that will help you understand exactly what I'm talking about. So let's say you're on the highway and you get pulled over by a police officer for speeding. And the police officer runs a history of your license, and it turns out that in the past year you were speeding 5 times. You got 5 speeding tickets. And the police officer simply writes you a ticket. Why? Because he said, listen, you were speeding 5 other times this year. Therefore, in this instance, you must be speeding as well. And you know in your heart of hearts that you were not speeding. But yet you're arguing with the police officer. You're not getting very far. And he says, listen, I know you were speeding. Why? Because you have a history of speeding. Well, you know that that's not right. You know that that's not fair. So what do you think happens? It's not fair for you to get a ticket, a speeding ticket, because if you weren't speeding, you shouldn't get one. But the police officer in this instance wants to write you a ticket because of your past history. The same analogy applies to a doctor who's fighting a lawsuit. Now, with a history of 25 other cases in the past, just because somebody brought a lawsuit does not automatically mean that it's valid and does not automatically mean that it's been conclusively shown that he violated the standard of care causing this patient injury. So now let me address the other issue that is really important. If you can't use this information at the time of trial in front of a jury, how can you use this information? Well, there's a key strategy to using this information, and that is during the course of settlement negotiations. When you enter into settlement negotiations, if you do at all, with the other side or with their insurance company, they will know that this doctor has been sued many times before. They will already know his past history of being a frequent guest of the court system in the civil court system. So this will come as no surprise to them. However, the mere fact that you make them aware that you know about his past history certainly has an effect on the insurance company. And let me tell you how. Excuse me. It doesn't have an effect of a threat, but instead it has an effect on, hey, listen, we've got a strong case. We understand the doctor has been sued many times before. There is prior testimony, and this is the second way to use it. You can now use it as leverage. There is prior testimony the doctor has given in his other lawsuits that is inconsistent with pretrial testimony that he's given in this case. Now, assuming that's true, you now have additional leverage for your settlement discussions. And that's very, very powerful, and it's very useful. So the other way that we use this information is that now that we know the doctor has testified in pretrial testimony, in depositions, in other cases, what we do as far as preparing for this particular trial, for your trial, we will reach out to the attorneys who represented the patients in those other cases. And we will say, hey, listen, I have a case involving a patient who had the following problems, and now we're suing the same doctor that you guys sued a number of years ago. I see you have a transcript. I see you have a pretrial testimony of this particular doctor. Would you mind sharing it? And most of the time, they'll say, no, of course not. And many of them will simply give us copies of the transcript of the doctor, and some of them will ask us to pay for copying costs, which is not a big deal. So that's another key strategy of how we use that information in order to help your particular case and in order to have discussions, settlement discussions with the defense when it comes time to trying to resolve your matter. So let's go back to the original question I raised earlier at the beginning of this video. Once you learn, or once your attorney learns that your doctor, the doctor whom you have sued, has been sued many times, guess what? You believe that you can use that great information to show to the jury, hey, listen, this guy's been sued 25 times, therefore he must have done something wrong in my particular case. Well, no, you can't use that at trial. But there are other key strategies to use that will help you leverage that information, hopefully to a successful result. So why do I share this quick video with you? I share it with you for two reasons. Number one, it's showing up on your Facebook feed, and now hopefully you'll get some great information about how this type of case works. And also, if you're doing a search and you find this and watching the replay, and you have questions about your matter that happened here in New York, because you know I can only answer questions if it happened here in New York, because I only handle cases or only practice in New York, then what I encourage you to do is pick up the phone and call me. It's true. I invite you to pick up the phone and call me. I can answer your legal questions. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day. Bye-bye. Take care, everybody.